Go. Well, hello, everybody, and welcome again to the next interview in the series of Iowa Prison Perspectives. This series of interviews is a collaboration between the Iowa Justice Action Network, Iowa Cure, and Living Beyond the Bars of Iowa. And the purpose of this is to inform you, the public, about the criminal justice system, what goes on, and also about the prison system in Iowa and what happens when people are incarcerated. We believe that there are a number of misconceptions, a number of things that people just don't know about. They aren't even misconceptions. Some of them people just are not aware, unless you have someone in the system or you know someone in the system. There, you just would not necessarily be aware. So what I'm trying to do is to bring light on the issues of the criminal justice system and the prison system by interviewing people who work in the criminal justice system, who have been incarcerated themselves, who have a loved one who's been or is currently incarcerated, and advocates like myself who are interested in seeing and getting the information out to the public and making some changes and some reform for the better. Let me just say to start with, as I try to say most of the time on these interviews, there is no one that I am interviewing that believes that everybody should just be left out of prison, that we should just open the doors and let people out. We're not advocating for that at all. Those of us who are advocates, there are people who belong in prison. I'm a big believer, and so are the people that I work with, and the majority of the people that I interview believe that we need to incarcerate people that we are mad at, that have done something very, very wrong. We need to not incarcerate people that we're mad at. And we need to not punish people for being poor or because of the color of their skin or because of their religion or any of the other issues that oftentimes happen. We're always fortunate to have who we're going to have for an interview. I think once again, I want to say that we're especially fortunate today to have Aaron Hawbaker, who happens to be I will let him give his title. I believe he is the chief or the supervisor of the public defender's office in Blackhawk and some other counties. So he will be letting you know what his actual title is and the counties that he covers. The public defender's office has many duties, and the public defenders are oftentimes overworked. So I'm going to let Aaron initially talk about what the duties are and introduce himself and tell you a little bit about the counties that he serves. So Aaron, it's all yours.
All right, Sue, thank you. And I appreciate you inviting me to participate in this. I am actually technically, the state of Iowa would call me a supervisor, colloquially, and kind of we're also known as chiefs or chief public defenders. The state of Iowa has kind of a two-tiered public defender system in answer to Gideon versus Wainwright, which was the Supreme Court decision that guaranteed a constitutional right to effective counsel. We have state public defenders, which is what I am part of. And we have local offices in that system. Waterloo's one of them. There's one in Davenport, Cedar Rapids, Iowa City, Des Moines, that sort of thing. And then if there's an overload or cases that we can't handle, then Iowa has a contract system set up where private attorneys, people that aren't employed by the state, can sign up to be assigned cases and paid an hourly rate by the state of Iowa. That's how we manage our case load, Sue, is that we, even though by statute, if you look at it, it looks like we have to take everything because we're responsible for all indictable offenses that happen in Blackhawk County or any other place that we're designated to do work. There's a relief valve in that statute that allows somebody like me to refer cases out when I'm of the opinion that we're full. We have too many cases, and it starts affecting our ability to provide effective representation. And so that's kind of a daily challenge for me, is monitoring how many cases we have. But that is our responsibility. Our responsibility is to represent people that qualify for indigent defense, and that's related to a formula and where somebody fits in the poverty line, how many dependents they have, that sort of thing. And if they do, oftentimes the court appoints us We can take cases on our own if we want to. The law allows for that, assuming people otherwise qualify even without the court appointing us. I do that on occasion just to step in and help out. And on occasion, we go outside of Blackhawk County to Buchanan County, Fayette, that sort of thing, especially if it's a more serious charge. And so that's our responsibility. We do not do any civil work. We don't file lawsuits. We don't do anything that often people associate with attorneys. We are simply criminal defense. That's our area of expertise.
And am I correct that once a person has had their either pled out and is sentenced or released, or if they have a trial and it's over, that you are then out of the picture, that you do not continue with cases after conviction or release? Is that correct, or am I wrong about that?
Well, we don't continue with it if it's done at the district court level. If it goes up to if we, let's say we have a trial and we lose and we want to appeal it, then we file a notice of appeal. That's our responsibility to perfect the notice of appeal. And then we file an order appointing the appellate defender, which is in Des Moines. They handle the appeals. And then we're out of it once the Supreme Court appoints somebody other than us in the case. You can have a conviction and you might have restitution issues or some lingering issues. So even though it's done or somebody's out, we still may have some things that we need to do to fully serve our client and kind of complete the case. But by and large, if there's a trial and it's not guilty, we're done. It's over. If it's a trial and it's a guilty and there's an appeal, then we're done after that's done. If there's a plea agreement, once the sentencing order is done and there's no lingering issues, then we'd be done in the case as well.
Okay, thank you for clearing that up. I think a lot of people wonder how come you're off the case basically after somebody is convicted.
Yeah.
It's easy to
yeah. We have to, if somebody's convicted and we hold on to it for 30 days to make sure to see if our client wants to appeal or whatever. And if we either do the appeal route or we get out of the case, because Sue, new ones come in every day.
Right. And you're always busy. How many attorneys do you have in your office, and how many cases do they cover?
We have 10 attorneys in our office, including myself, 2 full-time investigators and 3 secretaries. We have just been given what are known as FTEs or full-time employees, 2 new attorneys that we have. They have yet to be posted and we have yet to fill, but assuming everything goes according to plan, we'll have 12 at that point. The division of cases, versus the division of clients is really the difference, because you can have an individual that picks up 8 driving while barred. At the end of the day, it's still one drive. It's just driving while barred, and you're working with one client and trying to get it done. So it's a little bit more work, but it's not exponentially more work when a single person picks up extra cases. So it's really by client, and those numbers vary depending on the level. We have a loose system of felony attorneys versus misdemeanor attorneys. Misdemeanor attorneys are going to have a little higher level, and I can't tell you what the total number of that is, but we do try to keep it manageable. There's a fluctuation there. People that have the more serious cases are going to have fewer clients. Number one, they're more serious. Number two, it's more time demanding because oftentimes they're in jail. And so it's not just a phone call to your client, it's a trip to the jail and that sort of thing. And obviously there's just a lot more in the line, and it takes a lot more to work through, let's say, a first-degree arson than it does an OWI. I know that they have similar implications as far as somebody's criminal record and things like that. But when you've been doing it for 20 years like I have, it's pretty easy to analyze an OWI. But murder and sex abuse and robberies and things like that are a bit more work. Normally the investigations are more substantial in those cases too, Sue. So, whereas an OWI, you might have the body camera, of the arresting officer and and a couple of reports and maybe the dash cam from the car, the more serious the crime, they bring in the troops to do the investigation. And so you get a substantial increase in volume in reports and video and other physical evidence. And so it takes a lot longer to process and figure out a defense and that sort of thing. So actual numbers, I don't know. Over the course of a year, people might have, depending, 50 to 100 or something like that, individuals. Okay. And I always try to keep that level,
Yes.
but it's, the horror stories that you hear that I'm aware of too, let's say, for example, Louisiana, in particular, New Orleans, Missouri, other places, those are places where there's no relief valve. Those offices have to do it all. And that's impossible. I feel for those people. So while we carry a high volume and, our job is to do as much as we can without going to excess, it's not as bad in Iowa as it is in other places. I will say with anything, you name your profession, name your job, you're going to have different quality, whomever you get and whatever you do, different quality doctors, whatever, but for the most part, our system in Iowa, the way that we chose to set it up, has functioned very well. And I'm actually proud of it because I keep an eye on other other defender systems because I'm a part of some national mailing lists and things like that. So when I see what's going on outside of Iowa, I actually feel kind of fortunate. Now, that's not to say we don't have our problems, and we do have our big problems. But relative to others, we're doing pretty well. So yeah, it's a lot. It's a lot of work. It keeps us busy. Stuff, but normally, if you get somebody that stays with the public defender system, they have that level of commitment to and value in their job, regardless of money or how much work it takes, because they understand how important our job is. And those are the people I try to hire.
Yes. Yes. Another, I think, misconception that is out in the public is that a public defender is free, that you're entitled to an attorney, and that the state pays for that. Could you talk about that for just a minute about the actual, the cost?
Yeah, that does evolve over time, at least, but you're entitled to an attorney. Who pays for it is always up in the air. It has evolved, but basically the way to think about it is that the attorney is provided to you up front with no cost to the individual up front. However, both our office and private attorneys are supposed to bill at the hourly rate, which, by the way, is substantially less than what I would charge in private practice, which I think it's roughly in the $70 range with some variation an hour, whereas in private practice right now, I mean, you're looking at $200, $300, $400 an hour, at least in the state of Iowa. So it's a reduced rate, but people do get billed it unless there's a complete dismissal or an acquittal, a not guilty, that can get rid of the obligation to pay. Recently, the Iowa Supreme Court has read our statute to have judges determine whether or not somebody has the reasonable ability to pay certain types of financial obligations. It doesn't take care of fines. It doesn't eliminate the requirement to pay victim restitution. If you smash somebody's car, you got to pay them back for the car. However, it can reduce or eliminate an individual's requirement to pay attorney's fees or certain court costs. And if you think about it, judges are kind of two minds. I mean, some are, if you're working, you have the reasonable ability to pay. On the other hand, you're at such a point in the poverty level that you're required, that you qualify. So do you really have the ability to pay? And that varies by judge, it varies by jurisdiction and that sort of thing. But there's a way to get out from underneath that obligation, but it is not free. What changes is who pays for it.
So what you're saying is sometimes the state pays for it, sometimes the person pays for it, and that there is a formula for figuring that out.
And
Basically.
ultimately, a very loose formula, and ultimately the judges are the ones that make the determination, and there's some variance in that too. But yeah, that's exactly right.
Okay, well, thank you. I think that will help people in the public get a little bit more clarity on whether or not it's free.
Yeah.
And how those decisions are made, which is what the purpose of this is. Go ahead.
The other part of that, Sue, is that not only is it just the attorney hours, but in cases where we have to retain an expert, let's say we need to get a psychiatrist or psychologist on board, we want to have our own toxicological exam, we want to have somebody enhance video. Those are part of the attorney fees that are then billed to the client as well. So expert fees in particular can get pretty heavy.
So if I have a public defender and I've been charged with murder and I want you to have a particular expert about psychiatric stuff or whatever, can I request that?
Well, yeah, you can request it. Normally the attorney would make the call in conjunction with discussions with the client. I mean, there's sometimes, depending on the type of murder charge, where that's not even a defense. So you can't even, there are certain, like, for example, if it's a felony murder, where you don't even have to prove premeditation, it's not a specific intent crime. You don't have to prove the specific intent to kill. You just have to prove that somebody was participating in a forcible felony that led to the death of an individual. So then there's no reason to pay for a psychiatrist because it's not a defense. Those are hard cases, by the way. But yeah, I mean, the state, we would pay for it up front and retain them. And really, with a murder suit, really cost is no object. I mean, we do what we have to do our best to defend the case and put the best defense on, and we figure out the money later.
Okay, well, I think that helps, because sometimes people are under the impression that the public defender basically does nothing, just, shows up the day of court and talks to the client, and that's the first time they meet the client, and then you go in and you don't even necessarily know the case. So that's one of the things that I really want you to be able to clear up for people, to understand that that's not true, that it's not that you just show up and don't care. That was one of my concerns.
I can't speak for everybody outside of my office, but I can tell you everybody in my office, that's not true.
Yes. And yes. Thank you. Yes. Like you said earlier, there's a variety of people that get into any job, and there are some people who care a lot, some people who have a lot of compassion, and some people that just don't seem to, they're just going for the paycheck. So it happens in every profession.
And I can see people burning out. And then instead of getting out of the profession, which is what they should do, if they lose that empathy and that compassion, they hang around and they become that person you're talking about. And that is also a very real concern in what we do, is having people burn out. So I'm mindful of that too.
Sure.
That helps dictate how I view the caseload as well. And my people have a standing directive, or they have an understanding from me that I always tell them, the minute you think you're overwhelmed, you tell me, and I stop assigning them cases for a bit until they come back to me and say, okay, I'm ready to get back. I took care of my problems. I got caught up, and I do that on occasion. So, because it's one thing for me to monitor numbers, but they have a better feel of, sometimes you have more problematic cases that take up most of the oxygen in the room to the disadvantage of some other cases. And so when that starts to happen, my people know that they can just stop me from giving them cases for a bit, and and they're all such quality people, then they always will tell me, okay, now I'm ready to get back on it, but I can give them a couple month breather to get up to speed again. So
Yeah, I'm glad to hear that. I'm glad to hear that. I would like if every public defender and prosecutor operated that way. That would
Me
be
too.
awesome. Yes,
Yeah.
I'm sure. I'm sure you would. I'm sure you would even more so than I would. Um, Speaking of prosecutors, one of the things that I know is a concern of yours and is certainly a concern of mine and of the organizations that I'm part of is prosecutorial discretion. And I wanted to ask if you would be kind enough to talk about that
Sure.
to in your experience.
Well, my experience is it's not used really, but the the truth of the matter is this: is that no case has to be prosecuted. That's the truth. The county attorneys, as we call them here, not district attorneys or whatever, we call them county attorneys. They're the elected official. They're the chief law enforcement agent for that county and for the state of Iowa in that county. They have absolute discretion on whether or not something has to be charged. When I say charged, that's different than arrested. I understand why there are some needs for an arrest to happen just to diffuse, get somebody removed from a situation. Sometimes it's for their own safety. For example, I understand why um, since we don't have any other alternatives, and there are some communities that do, that if you have somebody that is just so drunk and on the street or otherwise intoxicated that they're a danger to themselves, you're worried that they're going to get run over in the street, or maybe they're so intoxicated that their heart will stop. And so oftentimes that ends up with a trip to the county jail just to get somebody detoxed and get it out of their system. I'm fine with that. You don't need to charge them with the crime though. You just need to get them help. And that's where
Yes.
that's where
Yeah.
the discretion lies, is that you can decide not to charge somebody where if that was more used, um, we could avoid a lot of our time being used on cases that just don't need our time and devotion. What's happening right now is that there is a shortage of people willing to do contract work, and there's kind of a shortage of public defenders nationally, and it's also true in Iowa. What that means is that the number of people that you have available to do that side of the due process coin is smaller, which means my answer to that is not to say, well, we'll do more cases. No, I'm not going to do more than what we do. Our constitutional responsibility is to provide effective counsel. And I'm not going to sit there and say, well, we'll take more cases because the system's broken. I'm going to do my job in the system, and that is effective representation. So what that means is there's a very real chance that we need to decrease the number of cases in the pipeline. That either happens by long-term decriminalizing a lot of things, law enforcement deciding not to arrest people, and I don't want to put it on their backs, because I understand there are circumstances where you just need to get somebody off the street or removed from a situation. But prosecutors can decrease the number of cases that are in the system by using that discretion up front, and they don't. To the contrary, oftentimes it can relate to abusive circumstances where I refer to it. There's lots of other ways where people will just get pounded into a plea. And it's a combination of prosecutorial discretion and the lack of or using it in a more vindictive or a mean way, and just to get a plea done or pounded out, and not what I would consider to be doing justice. I'll give you the example.
Yes.
The robbery second, I think I've talked about it before. For example, robbery second in Iowa is a 10-year it's a forcible felony. You have to go to prison. If a jury convicts you of that and you happen to be out on bond, you would be handcuffed and put in the jail that day. You also have to do 70% of it. You don't get the normal good time off of it. So you end up doing roughly 7 years. That's really beefy in Iowa. But the elements of robbery second are a theft or an attempt to commit a theft, and an assault during the commission or attempt to flee from the scene or the theft. So if you walk into a store and person takes a pack of gum And then as they're walking out, the clerk grabs them and the individual with the gum slaps them on the arm. And I've taught this at classes. I said, now, what do you think should happen to that person that took a pack of gum and slapped them on the arm? Most, college students will say a fine, something like that. Yeah, because those are two misdemeanors, a simple misdemeanor assault and a simple misdemeanor theft. Prosecutorial discretion would be, I'm going to charge it as a simple misdemeanor assault, and I'm going to charge it as a simple misdemeanor theft. Or you can use your discretion and say, but that's a robbery second, because the elements of a robbery second are the theft and the assault, which all of a sudden something that required that at worst could happen to them is 30 days in jail on each charge for a total of 60, now has a required 1070. And the jury never knows that. The jury is told that they have nothing to do with punishment, which I have a little bit of an issue with, because when the sentence is mandatory, which is what this is under the law, then the conviction is the sentence. Again, challenging that and having the Supreme Court agree with Aaron Hawbaker is difficult, but they won't know. And there certainly have been those cases where they'll convict somebody and they'll ask, well, what's going to happen? They find out and they go, geez, if we knew that, we wouldn't have. And so we rely upon the prosecutor to charge it in the just and fair way. Most of the mottos that you see at the courthouse are fiat justitia, which is Latin for due justice. And charging that person, what happens and has happened in my experience is that what will happen is they'll charge it as the robbery second. And knowing full well that that person is facing a 10-year mandatory sentence with 7, the plea agreement will be a 5-year sentence where somebody has to agree to go to prison, but there won't be a mandatory. So you're an individual that knows the facts and knows the law. You had no control over how it was charged, but you're having to make the choice. Do I want to risk spending 7 years in prison versus 7 months? And so that's how you pound a plea out of somebody.
And in your opinion, that happens, if I'm correct with what you're saying, that happens far too often.
Yes.
Yes. Yes. Yes. Do you?
And there's, yeah.
Oh, go ahead. Go ahead.
No,
No, you go.
And that's the system in which we live. We have, my hair stopped graying. Well, it still is, but at the rate that it was, when I've realized that I can't change the facts. I can't change the gun being stolen. I can't change the slap. What I wish I could change was the decision to charge as a robbery second. Now, they still would have the discretion to let them plead to the 2 misdemeanors. They still would have that discretion. The problem is there's these silly notions of, well, we don't want to come down too far. We decided to charge it that way. Therefore, that's what we think, which again makes 0 sense to me. But for whatever reasons, prosecutors in general don't want to vary too far from their initial charging decision as far as whatever plea agreement you have, because they look weak as opposed to just simply doing the right thing. So
there's also been some talk, I don't know if you've been involved in the conversation or not, but there's been some talk about people who are going to be charged and they are then offered a plea of like 5 years instead of, if they go to trial, they may get 10 years, and they refuse the plea and they go to trial, and then they're sentenced to the 10 years. And there's been some talk about why would you have to do more time than what the plea was that was offered to you? And I know it's because of the law. But what are your thoughts about that?
Well, that's how how it works. I mean, that's part of the inducement for the plea. You want to take the shot and risk that 10-year sentence, or take the deal and get 5. And the reality is that's how plea agreements, it's a bit of a gamble. It's like playing cards. You take your chances, and part of what we explain to people is what the risks are. That's our job. And I always tell people, my job is just to try to make you as fully informed as possible about what the law says and what the facts are looking at for us. And I've had the benefit of any number of jury trials now and kind of how juries see things. But at the end of the day, I walk out of the courtroom. It's not my decision. And so that person, what's faced with that choice, says, look, I want to fight it. I think we have a chance. That's fine. They have every right to do that. And oftentimes they should. Sometimes it works out to their benefit. But when it doesn't, that's an awful bitter pill to swallow. But that's what plea bargaining is. The bargain is getting something less than what the law would require if you're convicted of that crime.
Yes. Yes. Do you ever see times when there are charges added to put someone in a position of, like you mentioned, pounding a plea, where there are charges added that
actually, actually, the classic example is not charges added, because charges added gets a little bit goofy with the 45-day speedy indictment deadline and stuff like that, although it does happen. The classic example, which is going to be worse now, is look, they'll file, let's just take a third-degree burglary, which is a Class D felony. Okay, not a car, so it's a house. It's a Class D felony. It's a 5-year indeterminate prison sentence. It's not a crime of violence. There's nobody in the house or anything like that. It's technically considered kind of a property crime. You're, maybe 8 months in prison, something like that, before you're paroled. But we have a fight. We want to fight it because we were let into the house. We weren't there, and we weren't there illegally. This wasn't a burglary. This was maybe just a simple misdemeanor theft. And then the prosecutor would say, well, that's fine and good, but if they don't take the 5, then I'm going to file the habitual offender status. And then what the habitual offender status is, it doesn't require prison, but if somebody has 2 or more qualifying felonies, it doesn't matter how old they are. Could have been from the 70s. They don't age out. It could have been one when they were 18 and one when they were 20, and now they're 53. Doesn't matter. They are habitual felons. Then it turns that 5, or nickel as we call it, into a 15 with a mandatory 3. It doesn't require prison, but if you're sent, it's 15 with that mandatory 3. And as of July 1st of this year, the legislature has said that you do not get your 1.2 good time off of that mandatory. 3 means 3. And so it's an even bigger stick. And so then you're looking at somebody that, I got a shot maybe at this trial. They do have those prior felony convictions, so there's always a risk a judge might send you to prison if you're convicted. And the prosecutors, saying, I'll give you probation on the nickel, otherwise I'm going to file the habitual. Do you go to trial? If you win, you win. Let's take that out of here. I mean, the reality is that if an acquittal is an acquittal, I don't care if it's a habitual, a 15, a 5, a 30, a life, or whatever. If you win, you win. But if you don't, that's what you're facing. And that happens all the time.
Mm-hmm. And it's really sad. And and would you say that it makes people oftentimes bitter?
Mm-hmm. Yeah, me included.
Yeah. Well, me too, but I don't want to throw that in there until I got your opinion.
Well, I think that goes back to what you're talking about, Sue. I mean, why is it they get more if they go to trial versus if they take the plea deal? That's different. That's trial versus the plea. But why is it that if for example, that situation with the 5 versus 15, maybe it is like they have to, we'll do the 5, but they have to agree to go to prison because they have this criminal history. Otherwise, I'm going to file the habitual. And if 5 is enough, if the ultimate sentence of 5 is enough, why won't you agree to probation? Why do I have to be, or it's probation on the 15 with them? There's no logic to it. It's not. I mean, if it was just and true to do a 5-year sentence, then why are you even talking to me about a 15? So anyway, that's where some of a lot of the frustration comes. But.
Yes. And I do have one last question for you, and you're free to say you don't have a comment on this if you don't. My main concern in this work that I'm doing is about the families, and that includes the person who has been arrested and whatever they consider their family and whoever considers them family.
Mhm.
Is there anything, do you ever see families in your office? Do you meet with families? Do you offer any kind of help for families? Or do you know of any place that does? I mean, what is your opinion about what we do as a culture in our criminal justice system for families? How do we treat families of people who've been arrested and incarcerated?
Well, I think we tend to treat them like the arrestee, but um, the as far as our office is concerned, I mean, we have information on services and things like that are available, but we don't individually provide, service. Um, I meet with families all the time, but it starts with the discussion. If mom's in the room with somebody, I gotta say, look, I mean, you're giving me permission to talk in front of her because my confidentiality privilege goes to you and not to her. So if you want me to talk and just understand that, nobody will ever find out necessarily what we talked about. But from an attorney's perspective, I want to make sure that person understands that that's effectively waiving, at least as that person, the right to confidentiality. But it makes sense that people rely on family for kind of big decisions and things like that. And oftentimes people have family members that have been through it, so they kind of know what to expect. And um, I always, from my standpoint, I know that if somebody's sitting in jail or looking at going to prison, they need to maintain that support and that network because with very rare exceptions, they're always getting out. And so they need to have some place to go to, and they also need somebody to maintain contact with to maintain their sanity while they're doing their time. And so I have no problem keeping people informed, family or whoever they want, about what's going on. I don't talk about, unless they bring them to I don't talk about confidential stuff. I'll just let them know court's coming up and whatever. And if they have questions, I'll do my best to answer them if I can, just because that people are more than just themselves, and that they have maybe they have children that are relying on them and that sort of thing. So nothing concrete, Sue, just sort of, again, just trying to do the right thing.
Yes, thank you. Thank you for answering that. Go ahead.
Well, and it's also true that this is rarer, but I do have people that got nobody.
Right.
And they're either dead or they've been, or whoever they may have had once have disowned them because of whatever issues they've had in the past, and they've got nobody. And so, I'm currently sitting on 2 bags of property from the jail, waiting for people to get out because they didn't have a place for it to sit until they got out. So I once held on to somebody's property for 8 years.
Wow. Bless your heart. That's actually very kind and compassionate of you.
Well, it was funny because then I remember getting the phone call and say, "Hey, this is such and such. You remember me?" I go, "Yeah, I've got your stuff here." So I packed it up and I think I sent it to Georgia. So yeah.
I had a phone call from a man. This has been maybe 6 or 7 years ago when I was really working on not 6 or 7 years ago, a couple years ago, when I was working on the lifer commutation bill,
Yeah.
who had not talked on the phone for 36 years.
Wow.
It was his first time on a phone in 36
Yeah.
years. It broke my heart. I mean, that to me is heartbreaking.
And the phones have changed a lot in 36 years. Yeah.
For
Yeah.
sure. For sure. So, well, I want to thank you, really, thank you very, very much for taking the time to do this interview. I think it's so important for the public to hear from someone who actually does public defender work and runs an office to get some information that helps clarify what your duties are and what you actually do, and the degree of compassion that you have and that your office has. If you had the ability to make a change in the system, what is your major hope for the future?
It's a tough question. There's too many. The big change, and this will be a broader brush, but decriminalize things, increase treatment, mental health and drug addiction. Those are two biggies.
I could not agree more. I could not agree more. It seems to me that the whole war on drugs and the whole start of mass incarceration has done nothing but make a system that was already in need of some change 10 times worse. I mean, that's my own personal opinion.
No, and they go hand in hand.
Yeah, exactly. Yeah, exactly. And it doesn't work. It just doesn't work. So thank you very much. And I would also encourage, personally, I would add to that, not just adding mental health and decriminalization out here, but also adding mental health treatment when people are incarcerated and drug treatment that is really treatment when people are incarcerated. And I, I personally, I always have to say this, I would add something for the families also, for some family reunification that had to do with that. So,
sure.
So thank you very, very much for your time and your energy and for your willingness to inform the public. Really, really, really appreciate it. So in closing, once again, what I want to say to those of you who are listening is thank you very much for listening. And please get in touch with us. Please get in touch with us. Can be reached at Iowa Prison Perspectives at gmail.com. And that's IA Prison Perspectives at gmail.com. I really do want to hear from you, whether you agree with what's been said, if you disagree with what's been said, if you yourself think you ought to be interviewed, or if you know somebody that you think ought to be interviewed. This really is being done to inform the public from all perspectives about what our criminal justice in Iowa does and what it doesn't do. And we can't be more successful if we don't have you involved as the public. So please get in contact with us. And thank you once again for listening. And I will see you sometime later this week or this month. Thank you very much. Bye for now.